Hi, everybody. My name's Gregory Luce. I'm a U.S. born adopted person, born in Washington, D.C., and adopted in Washington, D.C. as well. I'm also an attorney. I operate Adoptee Rights Law Center here in my hometown, well, my adopted hometown of Minneapolis, Minnesota. And I'm also the executive director of Adoptees United, which is one of the national nonprofits representing all adopted people, both U.S. born and intercountry. And I'll talk, I think today a lot about what's really guiding all of my work right now, like 100%. And that has to do with citizenship issues or immigration issues for intercountry adoptees, especially those who are older, but it impacts almost every adopted person here in the U.S., especially now that there's been, as you've probably seen, a lot of immigration crackdown under the Trump administration that is very scary for many people if they are at, at the least perceived as an immigrant. And many intercountry adoptees are defined as immigrants, but also maybe perceived as immigrants as well, and maybe perceived as immigrants that aren't deserving to belong in the country, which is a double whammy, as you know, for adoptees, because belonging is such a big part of figuring out our identity. But I think what I'll do is I'll switch over to a presentation I've been doing for a little bit now. And every time I do it, I learn from people, and I also learn how to make it a little bit better. So I'm glad I'm able to continue to do this, and I keep tweaking it. So let me share that real quick. Right. So the what I've titled this over the years, maybe it's not years, but maybe about last year, is "Human or Alien: The Long, Difficult, Troubling Road for Intercountry Adoptees and U.S. Citizenship." And I kind of start with this photo because I find it both haunting and telling at the same time. This is a photo from the 1975, what's called the Baby Lift program, when they essentially scooped up Vietnamese children who were considered orphans, whether they were or not. Or some parents would get their kids on these planes and send them to the US for adoption. And these are kids on a plane. And what's haunting to me is, well, a lot of things. Kids just, there's a child in the foreground sort of looks like he's lost in thought, and who knows what's going through his head. And then the children looking out of the plane windows, but we don't know whether they're looking at the sky, they're looking at a Vietnam that's receding, or they're looking at a new country called the United States where they're going. And so I think that's often my guess is what goes through many adopted people's minds is of what did I see and where was I and how did I get here and what did I know as I went along this route. And then in the foreground is probably a white official that was in charge, or could have been an adoptive father or potential adoptive father, who was looking kind of glaringly at the photo. And I find that kind of interesting too. It's like, why are you interfering? This is how I interpret it. Who knows? Why are you interfering and why are you taking this photo? You're revealing something that maybe we don't often reveal. And so it really comes down to me as to this question of human or alien and how we treat intercountry adoptees, especially when they are defined under current immigration law in the US as alien. And so that's what this is going to be about. It's going to be about statistics, understanding how many intercountry adoptees came to the United States. I've done a lot of digging and parsing of a lot of data to go back to 1968 for most countries, a little bit further for Korea and Germany and Greece, because they were sort of this post World War II and post Korean War reasons for sending children to the United States. But as you can see from the map, that's Russia and China as these huge sending countries, more than 50,000 children over the last couple of generations. And then a small, tiny little country of Korea just under China. That's just to the left of Japan. And then those are the three major sending countries to the US. And then you have countries with a lot of adoptees that were sent to the US, such as India, Ethiopia in Africa, and Colombia in South America, and then tiny Guatemala that has 36,000 children from that tiny country being sent to the US for adoption. And that's generally the data that I've been able to collect from 1968 to 2023. We may have now the most recent data. It's not going to show a whole lot because it essentially international or intercountry adoptions have collapsed in the US and I think for good reason, even though they're still trying to um, get it back to the numbers that they once had, and but not having the countries cooperate in sending their children to the United States, and probably for good reason. Um, so I do from these data, I was able to create a a timeline over the years from 1968 to um, 2023 to show the growth of intercountry adoptees uh, and being sent to the U.S. for adoption by year, essentially. And obviously, when you start in 1968, there have been a number of um, adoptions that have already occurred. Some do not appear on this initial chart. Germany had a lot of kids sent to the U.S. immediately after World War II. Greece did as well, and anyone who's followed some of the Greek adoptees trying to regain citizenship or nationality with Greece will know about that. Kind of a sad um, story about Greek adoptees and being sent to the U.S. to Greek American nationals because of ideology, essentially. And um, but that precedes this 1968. But obviously, Korea is already by that time far ahead of any other country sending their children to the United States. And their program began in the mid 50s to late 50s and continued very strongly for almost the entire time intercountry adoption has existed in the US. Let me see if I can play this. You should see that map or a chart starting in 1968. I'm going to play it. It'll be a lot of silence because I don't have music to it, which would seem inappropriate, but it's going to walk you through 1968 to 2023. And I'd love to know what your response is to this. So I'll go ahead and play it as it's growing each year. You see Colombia now, when its program began in the early 1970s. India, the Philippines has always been a strong sending country. Mexico in the 80s. Then you have Romania, and now you're going to see China and Russia suddenly just boom. And then there's Guatemala, now the fourth biggest of all countries. And I always thought this was a really good way to show how many children have been sent from all over the world to the US. You'd call it migration, you could call it immigration, you could call it whatever you want. But we sent of these actually about, whoops, go back to this. And yeah, there we go. Let me do slideshow. Let's, are you seeing the full screen? I think so. Um, whoops. So you have 417,000 in this chart, and that includes adding Haiti, Kazakhstan, Thailand, Peru, Bulgaria, and Chile, as well as Greece, which had about 3,000 over the course of the first couple of decades of intercountry adoption, and then El Salvador as well. So these 20 some countries make up the vast majority of intercountry adoption to the US. The total number, um, and I'll just go through this real quick, but let me go to the total number first. It's 503,596. I mean, that's, it's obviously probably less or more than that actually, because the statistics I had did not count all visas, and many records were missing. This does not count children who were brought to the U.S. under the wrong visa or even smuggled into the country without a visa at all. And so it's likely larger than this 503,000 number. There were quite a few adoptions or adoptees sent from Western and Northern Europe. Again, this is generally in the 40s, 50s, and 60s, and often under refugee acts that were dealing with children who were considered orphans at the time and were sent to the US for adoption. Southeast Asia, with China and South Korea, are by far the most intercountry adoptees sent to the US. India and Philippines and Vietnam are also big senders. Russia, Ukraine, Kazakhstan are one of the some of the biggest, and Romania, some of the biggest countries there. But obviously Russia was big up until the well, until the early 2000s, I believe, maybe mid 2000s. I don't know the exact date for Russia when they ceased their programs. Africa, Ethiopia really stands out there, but there's quite a few from Nigeria and the Democratic Republic of Congo. South America, Colombia is the outlier as well, by far. And then you have tiny little Guatemala, which has had its very much trouble with intercountry adoption, a lot of corruption there, with sort of the same things that were done in many countries where the sort of the brokers for these adoptions would tell parents one thing and it would not be obviously true. Sometimes they would say that their kids are going to the US for an education, they'll come back, not true at all. Or they weren't fully orphaned, or they were simply stolen. And so that was a problem with Guatemala for many years. Guatemala does not now allow intercountry adoption unless they've just, I know that they have some um, legislation going through that they may reopen it, but as far as I know, they have not because of the corruption. And then North American and the Caribbean, there were quite a few from Mexico and Canada, and still some from Mexico as well. But Haiti is by far, or is generally the biggest sender of intercountry adoptees from that country. And so this is sort of the world picture um, by essentially by um, region. And that total is 503,596. Now, if you were to ask the Department of State, which regulates intercountry adoption, how many adoptions have occurred from sending countries across the world, their number would be 284,088. And that's because they do not, and no one I know does, track adoptions prior to 1999. And so you're getting a skewed understanding of how many intercountry adoptees came to the US from other countries. When the Department of State, if you go on their site without looking very closely, you'll notice that it's a number that's far less than 500 or 500,000 people. But you're only getting a small portion of the picture, about half. So we're dealing with 500,000 children brought to the United States, and then did they receive U.S. citizenship, and how did they secure that? Early on, obviously, it was not, well, I shouldn't say obviously, but because it should be obvious that if you're adopted by U.S. citizen parents, you become a U.S. citizen, but that's not the case. Early on, you had to naturalize those children who were adopted. And if your parents did not naturalize you, you never became a U.S. citizen. And that's one of the big problems with current immigration law in the United States. When I talked about human or alien, these are human, these are children, but immigration law defines them as an alien. And the term alien means any person not a citizen or national of the United States. This definition goes back, I think, into the 1700s. And so it's something that has not been changed over many hundreds of years. And it is a term that is considered pejorative. This is their glossary of terms. And then under prior administrations, the administration had changed how non-citizens would be referred to, and generally just called them non-citizens. But under the Trump administration, one of the first orders he signed was to go back to use of the term alien, because it alienates people. It makes them different. It makes them unhuman. It makes them un-American. And that's deliberately what the Trump administration is doing right now. They're making people who are immigrants un-American and not a preferred immigrant. So what to know about current law with intercountry adopted people and U.S. citizenship. This is the sort of who, what, when, how, and why. The who are foreign-born children who are now adults, and that's who I represent, who were brought to the U.S. for adoption by U.S. citizen parents. It's tens of thousands of them who lack citizenship. We don't know the full number, but tens of thousands could refer from anywhere from 15,000 to 75,000. We just don't know, because no one has ever tracked citizenship as an issue. And why are they not citizens? Well, there's a loophole in current law. And if you remember one date in immigration law for intercountry adoptees, the date's February 27th, 2001. That's when the current law went into effect, but anyone who was older or 18 or older on that date did not become citizens. They still had to naturalize. So that's that big loophole. And it's still, I consider, neglect on the part of not only parents for failing to naturalize their children as when they're minors, but also the U.S. has not fixed this issue. And it's not being fixed generally because immigration law is one, complicated, but probably more accurately, Republicans do not want to reform immigration law in the United States. They'd rather have a punitive system that allows only generally white people to, if they had their preference, to immigrate to the US. And that's true. I think when you see that the refugee program in the US is limited to 7,500 people, and almost all of them are white South Afrikaners, you really get the idea of who they prefer as an immigrant to the US, this current administration. In the US, there's two ways to obtain US citizenship, either by birth or naturalization. And what we mean by birth includes adoption. Adoption is, as you all know, uh, deemed as if you were born to your adoptive parents. And that's true to a certain extent with immigration. They have made exceptions to, or made sort of extended citizenship by birth to adoption, but under limited circumstances. Or you could naturalize. And the way I sort of distinguish between these two is that naturalization is a legal way to earn citizenship as opposed to be given citizenship. You have to live in the United States for a certain number of years. You have to take a civics test. You have to pass an English test. There are investigations of who you are. Do you have any criminal convictions? Do you have anything that would bar you from becoming a U.S. citizen? So it's a much more intensive process, and it's not linked at all to who you were born to or who adopted you. Now, adoption would make you a citizen if it's a full and final adoption, but except for those, obviously, who were 18 or over on February 27th, 2001. And that's that loophole. The other thing to know, too, is that there are two different orphan visas. Orphan visas mean it's not a true orphan. It's not that they don't have parents. It's that they don't have parents that are considered able to care for them. And so that's a pretty broad definition of orphan, but it's a definition that has existed for many years. But there's two visas, an IR3 and an IR4. You can see an IH3 and IH4. They're the same thing. They're just under a newish Hague convention, but they basically are the same. An IR3, the saying goes, an IR3, you're free, meaning that when you enter the country after full and final adoption, you typically become a U.S. citizen. There's a full and final adoption in the country of birth. An IR4 means there's more, and that's because you need to have a full and final adoption in the United States in a state court. So there's 51 jurisdictions if you include DC. And so in one of those 51 jurisdictions, you're going to have a full and final adoption, typically where the adoptive parents live. There are typically three requirements to get citizenship through your adoptive parents. You must be a legal permanent resident, meaning you have a green card. Adoption must be full and final, and that could be full and final in the US or the country of birth, but it does have to be full and final. No guardianship would allow you to become a citizenship unless you had an adoption after that guardianship. And you've resided in the US in the legal and physical custody of US citizen parents, and that has to happen after February 27, 2001. And this sort of summarizes current law. These three things have to happen, and you also have to reside in, well, that's one of the three things is residence and legal physical custody, but that has to be after February 27, 2001. And I'll show you why that's important in a bit. But this does not apply to those who are 18 you can't be older than 18 when any of these occur, and you had to be younger than 18 on the date of the Child Citizenship Act. So that must be younger than that. And the huge loophole is you're too old. And that affects about 75,000 intercountry adoptees. Yeah. So of the 503 that we can count, of those 74,000 were born on or before February 27th, 1983, which means they're 18 or older in 2001. We don't know how many of those naturalized later. That's not tracked, so we just don't know. I would just say that there's about 75,000 who are vulnerable to not having U.S. citizenship. And then, so what they have to do is they have to naturalize. Um, and that's because of the loophole. It costs $710 just to file for that, and it's using an N400 an application for naturalization. Another huge loophole, which many people don't know about, it only applies to a certain number of, and we don't know how many, but is that because you had to be in the custody of your parents after February 27th, 2001, you might have had kids placed in state care prior to that date, and they lost their citizenship when that happened, meaning that on February 27th, 2001, they did not become citizens. So, for example, and I have a client in this boat, she was born in the early 90s, came to the US as an intercountry adoptee um, after a full and final adoption in the country of birth, arrived in the mid 1990s. By the end of the 1990s, she had been removed from the home and placed in state care. On February 27th, 2001, she was not in the physical custody of her parents, and therefore she did not become a U.S. citizen. She has to naturalize. And I just find that just absolutely bonkers that you're abused by your adoptive parents and placed in state care. Not only does the abuse place you in state care, but that strips you of the right to become a U.S. citizen. Um, these are the about 210,000 arrived on this IR4 visa, meaning you had to have had a final adoption in a state in order for you to become a U.S. citizen. And this applies whether you were under 18 under current law or you're over 18. It applies to all intercountry adoptees. And so this is a more complicated case where no adoption occurred in the U.S. You do not become a U.S. citizen. You probably lose some privileges that would typically cover you if you were adopted by U.S. citizens. And I'm not really clear what your status is. You arrived as a guardian under guardianship. If you didn't have a full and final adoption in the US, which was required, your parents legally would be your biological parents in your country of birth. Now, this issue hasn't really come, I mean, this scenario has come up, certainly. The issue of who is your parent is something that has not been resolved. And so that's why we formed Adoptees United, formed the Citizenship Clinic. We formed it before Trump was elected for the purpose of essentially getting people a certificate of citizenship without having to pay for it at all. So pro bono representation, and there's no filing fee for that currently. And since we started in July of 2024, we now have we do have 215 active cases. We've closed almost 200, either because there's completed or there's no need for further representation. And we've done 404 total cases. So this is a massive number. And they almost all came after the election of the Trump administration, but by far most have come in the last 6 months as the immigration crackdown ratchets up, and especially here in Minneapolis. If you've covered the news from afar, you may know that Minneapolis was sort of ground zero for a lot of horrible things happening related to immigration. And so because of that news, our intakes to the clinic tripled in January, which means I'm still digging out from doing the work. Common case types. These numbers may not mean anything to you. Sometimes when I throw around these form numbers, people don't like, what are you talking about? But 174 cases are certificates of citizenship. Again, there's two differences. You have a certificate of citizenship, meaning you got citizenship through your parents, or you can have naturalization, which means you sort of earned it. By far, we're seeing a lot of N600s, the certificates of citizenship, because people want proof of that citizenship because of all the immigration enforcement that's happening in our communities. I'm doing less naturalizations right now, and I'll tell you why in just a bit, but we've had a number of those cases. And then we have about 60 cases where you had a certificate of citizenship in the past, but you lost it or you changed your name and you wanted your new name on that certificate. So we apply for a new one. Pretty easy. That the replacement one's pretty easy. There are other cases that are often more complicated, but that doesn't include just advice or what's called a FOIA. I don't know what they have in Britain, but it's Freedom of Information Act, where you can request your own records and get your immigration records within 3 to 4 weeks. There's now a problem under the Trump administration with that as well, and I'll talk about that. But I also have been increasingly doing green card renewals, meaning you are a legal permanent resident. You're not a citizen, but at least you have proof that you're legally present in the United States. There's some more complicated ones called temporary protected status that I have a client who's from Haiti with that. Adjustment of status means that you're applying for a green card, typically through a U.S. citizen spouse. And then I've got a number of them that are still being investigated because we can't figure it out because of the records that we either have or don't have. I might skip through this quickly. I just do what we would normally do in any law firm or legal clinic: screening, assessment, advice, and representation. But in the general, it's for those three major options: proof of U.S. citizenship, with its whether it's certificate of citizenship or a replacement, naturalization if it's warranted, or green card renewal. One of the new developments, and I talked about FOIA, is during the assessment part, we're trying to gather all the records that we can, but the Trump administration has even made that impossible or harder to do. They're redacting a lot, or if not most, of the documents from my client's immigration file. So it's really difficult to figure out sometimes how they came to the US, who their parents are, because they're redacting every parent name or any other individual's name in the record except for my client's. And even if my client had applied for a benefit in the past and had included her parents' names in her application, they're still redacting those, even though she's the one who wrote them in there. So it's been just a shit show trying to figure this out and help my clients. After advice, I give them options, and that could be for proving U.S. citizenship, securing U.S. citizenship, or any other issues. One of those is naturalization. I am not often now recommending naturalization, generally because even though it's pro bono representation, one, it costs $710 for the filing fee, and I would probably need to travel to the interview. But part of the problem is the client may have registered to vote or has voted in the past, even though an exemption exists for that because of if intercountry adoptees had U.S. citizen parents. We're very wary of calling attention to things that could be problematic, especially in the naturalization. Essentially, we're trying to avoid prying eyes of the federal agencies. And so when that issue is present, and it's common in many of my cases, we may opt for a different option. They also do criminal background checks to determine if there's a criminal conviction that would disqualify you from naturalizing. And even in situations where there is a criminal conviction in my client's past, depending upon what it is, I may not want to go forward with naturalization either, even though in the past, that type of conviction wouldn't have been a problem. Again, it's to prevent overreach from the administration in trying to deport as many people as they can for reasons that really don't hold up to the law. So that's why I'm not often recommending naturalization to my clients. It has to be a super clean case. No criminal conviction, no registration to vote, and no voting record. And those are uncommon because adoptees are human. Adoptees think that reasonably believe that they are a U.S. citizen because both of their U.S. citizen parents are. There is what's called the PATH Act that's pending in Congress that would fix this. And that would make these older adoptees who never received citizenship through naturalization, it would make them automatically citizens. And one of the things that is required is that they have a current green card. in order to gain that citizenship. And that's why I'm turning to renewing old expired green cards so that we have that proof. It's easier. It doesn't get into voting rights or claims to U.S. citizenship. Um, it does look into the prior interaction with the criminal justice system, but um, not as intensively as it would during a naturalization. It's a fairly simple process. It's less expensive. And if they have that green card and the PATH Act passes, they become a U.S. citizen. So it's a much safer, easier, sort of more streamlined option that I'm increasingly recommending because of the way the Trump administration is cracking down on naturalizations. Easy process, no interview. It takes 5 to 28 months, 28 months to get your green card, which is terrible. But there is an interim option to show that you're lawfully present in the U.S. So just imagine this, that you have your green card's expired long ago because you thought you were a citizen. You don't have proof of being lawfully present in the U.S. You need to naturalize, but naturalization may lead to ICE enforcement. It's got to be scary as hell to do anything right now with that kind of situation. So this seems to be, and my practice is generally like, what do we do that's safest and that makes you so that you are at least feeling safe? And this green card renewal is probably the one that we've picked. Even though it takes so long to get, it would buy you time. We can lay low, and hopefully they're going to fix this problem in the near future, and you become a U.S. citizen. I do have complex cases. Um, these are the cases where you arrived on a temporary visa and the visa is long expired. This is where adoptive parents cut corners and didn't go through the process of applying for essentially an immigrant visa, which is harder to get, and instead pretended that their child that they're bringing uh, from Colombia was a just visiting, just a tourist, and that's happened more often than we want to acknowledge. Or they may have no proof of even entering the country. This is, I consider, sort of trafficking, smuggling, again, cutting legal corners. And even though they are brought illegally to the country, meaning it's illegal on the part of the parents to do that, they were still adopted in state court. Courts many years ago didn't look at that and still and sometimes don't look at that, whether they're legally or lawfully present in the US. And then there's some cases where there's no record of any arrival to the US or an adoption at all. They really literally have no records. So the cases have difficult solutions. So I have a case where um, client came on in 2010 after Haiti, after an earthquake in Haiti. Many came on a humanitarian visa, including one of the children of Supreme Court Justice Coney Barrett. And a special law then allowed you to get a green card through the Help Haiti Act. And if you did, you became a U.S. citizen. Many parents didn't know about that, or they didn't take care of it, and their children never became a U.S. citizen. And they're in a world of hurt now because their humanitarian visa expired many, many years ago. So there are some possible solutions. They're not great, and some aren't even available. So sometimes there are no solutions to these issues. I have clients who are born and adopted in Mexico, but arrived in the U.S. after being waved through at the southern border, basically meaning they were in their adoptive mother's arms as the car drove through from El Paso or from Juarez to El Paso. Very difficult case as well. You might be able to get a citizenship or green card through a U.S. citizen spouse. Sometimes if one of your parents is in the military, that could help. Increasingly, or not increasingly, but often, military personnel were involved in many adoptions, and so that could be an option. But again, these are difficult as well. If you've heard of DACA in the U.S., that is a form of deferred action for people who don't have lawful presence in the U.S., but as long as you don't have any criminal convictions and are employed or in school or graduated from high school, might be able to get DACA. But after many, many court challenge is you cannot currently enroll in that. You can only renew any prior DACA status you had. And then one of a case that I had that was, really interesting, but also very happy that we were able to do this. There's an old law that called the registry law. And if you were in the US continuously since 1972, and this is a person who has no record of entry, and you can prove that you're continuously in the US for that time. So 72 through, this client was in 2017 or so. For all those time, we were able to prove he was continuously never left. You can use a provision called the registry provision and get a green card. And it's actually fairly easy, a lot easier to get a green card that way as well. I say this because this is one solution that could help not only intercountry adoptees, but other immigrants who have been in the US for many, many years, have not left, have been working, they don't have any convictions. If you were just to move that date up from 1972 to 1986 or to 1990, so that people who are continuously living in the US from, let's say, 1990 to 2026, that's 36 years. That's a pretty good indication that they're staying. And so if they were to move that registry date up, that would help an immense number of people as well as some of our clients. And this is sort of the bread and butter cases, proof of US citizenship. If you've met all these requirements under the current law, then you need a US passport, a certificate of citizenship, and that's what we help you get. That includes 100,000 intercountry adoptees who weren't automatically sent a certificate of citizenship, which didn't start until 2004. So let's say many of my clients are from China. I think I have equal number of Chinese adoptees and Korean adoptees of around 100 and 104 each. And you arrive, you are a citizen under current law, but you don't have proof. You either don't have a passport, you don't have a certificate of citizenship. That's the process that we follow for this 100,000 people, is to get them their proof of citizenship, whether it's a passport or a certificate or both. I mean, I recommend having both because the more proof, the better. And then you have about 135,000 who do also qualify because they were under 18 years of age as of February 27, 2001, and they had a full and final adoption in state court. These are these IR4 visas where you had to have a finalized adoption in state court, and we're assuming they did. So it's another 135,000 would benefit from getting a certificate of citizenship. The typical process for that is it's free representation. It's filing a Form N-600. There's no filing fee because intercountry adoptees are exempt from that as of April 2024. There's no interview. You file electronically. The biometrics is very simple. Biometrics for a lot of benefits involve fingerprints, criminal background checks. It does not for a certificate of citizenship. And the two appointments you have to make are biometrics, and you also must take an oath of allegiance to receive the certificate, which sounds weird, and it is weird. You're already a US citizen, and yet at the end of this process, you have to take an oath of allegiance. And currently it takes about 5 to 10 months from the date of application to getting the oath or taking the oath and getting your certificate. One final thing on what's making it hard in the US, and this is sort of when you intersect intercountry adoption with US domestic adoption, is one of the documents you need, especially for these cases where you had to have a full and final adoption in state courts, you need an adoption decree, a certified copy of the adoption decree. And as many people know, you can't easily get a copy of a court record from a US state court, especially if it's an adoption record. And so we're having trouble getting certified copies of adoption decrees from state courts, even though that's an essential document for US citizenship for intercountry adoptees. Because I was having so much frustration, I'm in Minnesota, I wrote a bill. It's in file 4382. It's currently active. It may take another year to get it enacted. I think it's an easy one, but basically, if you're an adult adopted person or you're an adoptive parent of a child, you can, upon request, get a certified copy of the adoption decree. which sounds extremely simple and easy, and it is. And it's just common sense. And part of the problem is there are 87 counties in Minnesota, which means there's about 300 different district court judges. And who you apply for right now to get a certified copy of a decree, whoever's reviewing that may have a different opinion than the judge a county over. And so it's complicated, it's confusing, it could be expensive if adoptees feel that they can't do it themselves and need to hire an attorney. And it's just ridiculous that you can't get this critical record. So hopefully we can fix that part and make sure that people can get a certified copy. I mean, everyone across the country should have at least the ability to get easily a certified copy of their own adoption decree. It's just ridiculous that you can't. And then this is actions you can take. I have this as for people who are in Minnesota and the US to take action. And then these are the resources that currently exist if you want more information. So adopteerightslaw.com, that's my law firm /citizenship, or adopteesunited.org that funds and oversees the clinic /citizenship. And it has resources there, and we're trying to always add more. So I'll end it there and take questions. So let me